StudyIQ IAS, अब तैयारी हुई अफोर्डेबल।
Women harassment has largely been a very important concern faced by the societies irrespective of their level of development. When some blames the harassment on the patriarchy, some discusses the notions of harassment based upon the economic factors. Yet other discusses the notion of harassment on the basis of illiteracy or underdevelopment. Whatever may be the cause of harassment, harassment has remained an important, unfortunately, an important empirical reality of the modern societies. Not only the modern societies, but the traditional societies equally were facing different forms or propagating different forms of harassments with respect to the woman as a gender. Recently, the topic of women wrestlers has been the topic of debate, discussions with respect to the sexual harassments faced by our players. Different aspects have been dwelled on this. I'm not going to discuss the topic of women wrestlers becoming the victims of harassment. The need first is to understand what is the law present, what is the protection given to the very women who are today going with confidence to the work, but the very work becomes the mechanisms of killing or suffocating their confidence and largely prohibiting them to participate in the economic spheres. As a result, we often see, despite the high economic rise, there has been a fall in the work participation rate. What is this law? How this law has worked in the previous decade? And is there any necessary changes which we need to make? But before starting to the law, let's understand the situation which the woman often faces or goes through, unfortunately, when they become a victim of a particular sexual harassment activity or an incident. In the recent time, if you see, Delhi police was there in the limelight, where the mechanisms in which they wanted to largely investigate this complaint of women wrestlers was something which was largely not expected by by a machinery which implements the very laws framed by the parliamentary representatives. Delhi police has asked for a video and audio proof of sexual harassment from the complaints in the ongoing sexual harassment case against the president of the Wrestling Federation of India. I mean, can you expect this? The audio and video proofs. Is the woman aware that she would be becoming a victim of such an harassment? This raises several concerns about the investigation protocols, which is expected to be followed by the police in the sexual harassments or the offenses which largely carry sexual harassment aspects. The lack of sensitivity and victim-centric approach taken by an Indian investigating authorities and the blatant violation of settled legal norms is what this particular incident reflects. The case is not about whether the wrestlers became the victims or not. That is depending upon the law, how it is going to largely take place. The case is more about whether, if those women have largely become the victims of an harassment, is the mechanisms to investigate such a case does exist, and if it is existing, then is it followed by the very law and order mechanisms and machineries? Not only followed, but is the mechanism very much victim centric, or is it something which largely deprives of the victim's basic rights? Several women wrestlers have been protesting. Issue क्या था? Against the WFI president at Delhi's Jantar Mantar, but no action was taken against him. No issues. Chalo, protest may happen. Let's see further. On 21st April 2023, two complaints were submitted to the police. One involving the complaint of 6 women wrestlers and the other involving the complaint of a minor wrestler for offences under the Protection of Children from Sexual Offences Act 2012. Clearly indicating that how we often see that the harassments often are not taken due care. The protest may have been different, but at the same time, when the complaints were submitted, the police largely asked a video proof. Let's see. Before, just a small amount of information that our August batch for sociology is now open. Those people who are interested to take their sociology to the next level should definitely get into this batch. And as I always say, do not trust my words. I may be here for the admissions, but technically I'm not. But this is something which normal student would often feel. Do see the videos which we have at this platform. And if you still find any content better than this, then definitely you should join that particular organizations. But if you yet are not finding that same content and at the price which is almost 1/4 of any organizations present in India teaching sociology, then you should certainly get that covered here in this batch. In 5 months span, we'll cover the entire sociology syllabus from head to toe. Coming further, in the WFI case, the ICC had not been constituted. Internal Complaints Committee, which is largely an obligation for Sexual Harassment at Workplace Act, under Sexual Harassment at Workplace Act, which was a serious violation of the very POSH Act, Prevention of Sexual Harassment at Workplace. In the absence of a legal recourse within the WFI, and when the women were largely not having this internal complaint committee, they started sitting for a protest. And lack of institutional support regarding their allegations, women wrestlers have chosen to pursue criminal actions against the WFI president now, after a strong protest where it has received support from the entire Indian community. The Supreme Court, there is one particular incident in Vijay alias Chini versus State of Madhya Pradesh in 2010, that's almost 15 years down the line, ruled that court is duty bound to treat cases involving sexual harassment or molestation with utmost sensitivity. Evidence of a victim in such cases enough for conviction, and court should not ordinarily require corroboration if such evidence inspires confidence. So if the victim's evidences are inspiring confidence, then unnecessary corroboration of evidences should largely be avoided. The victim's word should be treated as the final culminating point, not opined personally by me, but opined by the highest judicial body of our country, that is Supreme Court. The cases of Supreme Court is a Supreme Court is a court of record, and its cases can be applied throughout the country. The challenge faced by the complaints in this case and the approach of the investigating agencies are indicative of a trend that not only risk discouraging the victims from reporting any such instance, but also invariably pushes women out of workplace. The very approach adopted by the very Delhi police has often been criticized by the various intellectuals or the law implementers, as it will not only discourage women, but at the same time it will also be responsible for largely keeping women outside the economic structures, because there is a possibility these women may develop a fear because of the lack of alternative support provided by the law. They may not even join the workforce. Then what is the point of that Beti Bachao and Beti Padhao, where that padi hui beti would not even be capable to work, but would be afraid to work? Are we going in the right direction? Is the march of youth being in the right direction? This is what the Sabka Saath and Sabka Vikas should look like? Is this the basis upon which we want to become Atmanirbhar, or is this the basis upon which we want to become Vishwaguru? It's not about against any political party. It's not about against any ideologies. Ideologies are good on papers, but in reality, it is the people, it is the humanity, it is the moralism which needs to win. And as far as the approach adopted by certain organizations that does not build that confidence within us to send our daughters, our mothers, our sisters to an environment of a work where they are more prone to get harassed than being protected. Let's see, sexual harassment at workplace. इस act के बारे में देखते हैं, because this is something which is there in the debate, not the issue of wrestlers. Almost 24 years after India got its first guidelines to prevent sexual harassments at workplace, and 8 years after the government enacted law for it, there are few publicly available data on the very implementation of the act. I mean, why there has not been any study? Why can't the social audit of the very implementation of this act be made compulsory? And once you do not have a data, the things always are like stories and gathas which are not having any empirical evidences. But there are certain organizations which have largely collected data which are scattered. Let's see into those. In fact, the government maintains no centralized data relating to cases of harassment of women at workplaces. The parliament was told in July 2019 that no centralized data is maintained. Also, 95% of India's women workforce are employed in the informal sector and find it difficult to access legal mechanisms to report sexual harassment at workplace. Experts told India Spend, which is an organization which conducted a study on this very implementation of the act. Some recent cases, let's figure out whether this sexual harassment at workplace is building some confidence among the women to largely participate in the work sphere. On Feb 17th, that is 2023, a Delhi court acquitted journalist Priya Ramani in a defamation lawsuit filed by a former editor and sitting member of parliament MJ Akbar for accusing him of harassment in 1993. I mean, what should I say or what you should be listening to this? At least the silver lining is this: she was acquitted of defamation case filed by this person on put up on this particular woman, that finally the court acquitted her of any defamation. Reason? The woman has a right to put her grievances at any platform of her choice. And even after decades, said Judge Ravindra Kumar Pandey in his judgment acquitting Ramani of defamation case. People were often debating if this female has largely faced a sexual harassment, why is she complaining after years and years and decades? The judge clearly made it that yes, she has a right to put her grievance at any platforms, be that Twitter, be that social media, or be that any place else. He also noted that at time in 1993, she had no avenues to seek redressal for her alleged harassment. The act did not exist. The guidelines of sexual harassment at workplace did not exist by then. As India formulated the Vishaka guidelines to prevent sexual harassment only in 1997. And the guidelines evolved 16 years later into Sexual Harassment Act somewhere in 2013. Therefore, this woman had no avenues there. And as a result, she put up the avenues, she put up her grievances at different platforms, commonly known as Prevention of Sexual Harassment Act, this act we are talking about. So the judge justified her position and stand, and he refuted the no, it's not a defamation. While Ramani's acquittal in the defamation case is a victory, but at the same time, those people who are largely being harassed, is the law now which we have, POSH Act, is this working? Let's look into this. Independent research has found low overall compliance of the very sexual harassment at workplace. The majority, 56% of the 655 districts upon which the study was conducted, did not respond to requests to provide data on the functioning of local committees to look into the workplace sexual harassment. And 31% companies surveyed in 2015 were not even compliant with the law. Now, what happens in this law is, कुछ ऐसा सा aspect है, to make it simple to you so that you understand this entire thing in a very pragmatic manner and it becomes end. Sexual harassment at workplace. I'm just writing simply a short form of it. Prohibition, obviously. A company employing 10 or more people should have internal complaint committee. Any organization having 10 or more women workforce should have this legal obligation. Less than 10, then there is a committee at the level of district. Now, what this fact says, district level pe 56% did not respond. And at the company ICC level, we see that 31% did not even constitute this. That means the very law, which is a binding obligation for the companies and the districts, they themselves are not following the law. Forget about its implementation. Application of the law देखते हैं कैसे apply किया जा रहा है ये law. Many women are excluded from this. How? Let's see. The Prevention of Sexual Harassment Act requires that any company, जो मैंने आपको बताया है, 10 होने से ICC, less than 10 होने से district committees होती है. Every district also ought to create a local complaint committee to receive complaints from companies with fewer than 10 employees. and from informal workers including domestic workers, ASHA workers, everything. That means those companies which are having less than 10, एक district committee होती है under the district collector, where these companies can largely, those people involved here can complain about any sexual harassments. Many women are largely covered here. But many of these women are working in informal sectors, so in a way they technically get excluded from all of these ventures, and that many comes to 95% of women workforce. Filing of complaint. How is the complaint filed? Under the law, any woman can file a written complaint either to the internal complaint committee or a local area committee in the district, depending upon where she is working, within 3 to 6 months of the incidents of sexual harassment. The issue could be resolved between the woman and the respondent, or uske baad the ICC, which takes into account, or the district which looks into the complaint, takes an appropriate measures. So a woman files the complaint, then it is dwelled upon, discussed upon, and then finally an action is taken. Women can also file complaint through Women Ministry, Women and Child Development Ministry, Sexual Harassment Electronic Box, which is called as She Box. So electronic complaint can also be found in this particular context. And this electronic platform started way back in 2017. Fall of follow-up mechanisms. Once a complaint is filed, a follow-up mechanism is taken up, but in reality now what is happening? Every year, internal and local committees have to file a report. To whom? To district officer, with details on the number of cases filed and the number of cases studied and what are the actions which have taken up. Therefore, it's an obligation for these complaints committee to largely give a follow-up actions, that what they have done on the complaints which have received and how many cases are pending. The district officer should also forward a brief on all annual reports of companies with the details on compliance to the law to the state government. That means, let's assume I am the district officer, all the complaints committees would brief me about it. I would have to brief it to the respective personality or the positions present in the state government. Therefore, a very perfect mechanism has been created. हो क्या रहा है? Issues with the law. The law is very simple. Complaints committee, less than 10, तो district में, more than 10, तो within the company would look into this. Company would largely submit a review to the district officer. District officer would brief it to the state government, and this is how the mechanism is built and accountability is ensured. Let's look into what are the issues in the law. Is the law working? The majority of the Indian women workers find it difficult to access these redressal mechanisms. As far as the electronic mechanisms is concerned, the very internet connectivity is low. Sikkim ke andar roughly around 77% women have used internet, but in the context of Bihar, only 21% have ever women have largely been considered to have used internet, clearly indicating that electronic mechanisms would not be an appropriate way to tackle the complaints here, as elaborated or corroborated by National Family Health Survey 4. Sometimes the institutional process are unclear even for women in the formal sector. For example, in 2019, when a woman working in the office of then Chief Justice Ranjan Gogoi tried to launch a sexual harassment complaint against him, it caused a dilemma for those who had looked into the matter. Now the people were not clear enough, okay, how should they look into this? Because at this level, if this harassment has taken place, there are many dilemmas which are often present, okay, now where we should report it. If you are reporting to ICC, then where this ICC would report it into the district. Imagine a Supreme Court machinery reporting it to a goddamn district collector or at the district level officers. Confusions are there in certain POs. Dysfunctional committees. Many people have formed the committees, but how they are functioning, let's see. District local complaint committee are not functioning meaningfully. कौन? मार्था पेरवेल फाउंडेशन की आरटीआई से पता चला है ये. A न्यू दिल्ली बेस्ड ऑर्गेनाइजेशन है where they advocated local complaints committee are not working, जिसका फैक्ट मैंने ऑलरेडी बताया था. Again it is mentioned here. The foundation has asked how many local, this was the information which they asked, how many local committees were formed, how many actions were taken, how many complaints were received. Now what happened, or what the reply the Martha Farewell Foundation got is this. 655 districts के अंदर 56% of them they reached out, they did not respond to the request. RTA का कोई reply नहीं है. Only 29% said they had local complaint committee to look into the workplace, and 15% said they had not set up a committee. Majority did not reply. Some who replied, they said they have. Some who replied, they said they have not even set up. I mean, look into a law which is an obligation which is not followed in India. And that's the reason we often see that the women often become the victims of sexual harassments at workplace. Let's go further on fact. Representations on committee. क्या होनी चाहिए और क्या वो लॉ का अनुसार फॉलो की जा रही है? Although the law requires that these committees should be headed by a woman, and they should have at least 5 members, including one from an NGO. This was not followed on the ground. Ground level pe this is not even followed, that the men largely becomes the head of internal complaints committee, which many times largely may not motivate the women to largely put up a complaint, as it may not be biased, but it does create an image of being biased. Data available. Central or state government do not even collect publicly the data of implementation of this very act. This PPT would be sent to my Telegram channel. Please do join that up in order to get these PPTs. This is a serious question. Maybe if not this year, but in coming 1 year, this question would definitely become part of your examinations. And if it's not part of the examination, you should at least have the capacity to learn the laws which are largely prevalent. Who knows? Who may require your guidance in what circumstances? God forbid, you may not require, you should, I hope you never require this, but there are certain women whom you can help if unfortunately they have become the victims of this. Do read this pendency of complaint. Many complaints are largely pending. There are very good facts which are found out. She-Box had received 612 complaints, electronic mechanisms of Women and Child Development Ministry, 196 from central government, 103 from state government, and 313 from private organizations, as per government response to Rajya Sabha in 2019. Therefore, ये तो properly authentic data होगा. But there is no method to track the complaints on year basis. How many of them were resolved? Something which has not been tracked. For instance, another government response to Parliament last Feb mentioned that nearly 70% of the 539 complaints filed between November 2017 and 2020 were pending. That means neither we are properly collecting the data. Even if we are collecting certain data, we are not even keeping a brush with those data collected, that how many actions have been taken. What is the pendency? Now, looking into all these, we clearly come to a conclusion that the law for the protections of women does exist, but that law is insufficient as far as its implementation is concerned. Most of the times, we often say that how protective the laws are, but in reality on ground level, what is their implementations? I have explained you purely by logics and facts, not by any ideologies. What should be the way forward? The government should publish data on the number of sexual harassment cases received and resolved by local district committees, and also conduct a nationwide audit. Technically, there should be certain social audit mechanisms as soon as possible should be introduced in the Prohibition of Sexual Harassment at Workplace 2013. If this is the way, do join our batch. But before concluding this entire topic, there's one thing which I'd like to share with you. We often largely advocate there are very pro-women measures which have been taken in the Indian societies in the recent past. But in reality, we often see they are not implemented. Therefore, what India requires is not merely the stringent laws. Stringent law is one part, but many laws, if not maybe strongly stringent, but a stringent implementation is something which we require it on urgent basis. Therefore, the various pro-women laws does exist, but the question remains to what extent it is implemented. Hence, it's high time, because of the very case of women wrestlers who themselves are largely not feeling safe. How can we expect those women who are not having access to internet, those women who are not even many times are aware of their rights, would be protected at their workplaces? And in the capitalistic systems where the market phenomena dominate to such an extent, in such categories, we often see that if adequate measures for the protections of vulnerable sections are not taken up, there is a possibility these women in this context would be more exploited than empowered by the very economic representations which they today have. और इस तरीके से अगर आपको कोई conceptual clarity sociology में रखने की इच्छा है और आपका ये optional है, do join our batch. Thank you. You can use the code DIVLIVE. The batch starts from 16th of August. Thanks.
StudyIQ IAS. अब तैयारी हुई affordable.